Hello, and welcome to our webinar, Making a Will and Estate Planning Tips. I'm Judy Spiegel with Penn State's Office of Gift Planning, and we are pleased to host today's webinar with the Penn State Women's Philanthropic Advisory Board. The Office of Gift Planning's role is to promote the planned gift across the Penn State institution, and we provide education and information to our donors to help them reach their financial and philanthropic goals. Of course, we recommend that you work with your advisors to do so. Our office is staffed with a team of experts, including Pat Roenick, who is one of our speakers today. We think today's message is important in light of the fact the great wealth transfer in America has begun. What does this mean? Over $82 trillion is going to be passed on from older generations over the next 20 to 25 years. But Americans have an estate planning crisis. Only 34% of American adults have an up-to-date estate plan. Also of note, today, women control roughly 1/3 of total household financial assets. And by 2030, women will hold more than 2/3 of the wealth. Now, please welcome guest speaker, Lee Beard, Chair of the Penn State Women's Philanthropic Advisory Board. Lee?
Thank you, Judy. And thank you to all of you for joining us for this presentation. The mission of the Penn State Women's Philanthropic Advisory Board includes changing the landscape of philanthropy at Penn State by recognizing, as Judy said, that the women's share of wealth is on an unprecedented rise. Along with this rise comes the opportunity as well as the responsibility to manage that wealth, which includes having an estate plan in place. During my career, I also served as a bank president, and in that role, I recognized that a lot of women lack information on the importance of estate planning. This webinar will benefit both women and men by providing information on topics such as why a will is important and discussing other documents that are part of an estate plan. The presentation will list some of the next steps on getting started on your own estate planning process. Creating a will doesn't have to be difficult, nor does it have to be time-consuming. It doesn't even need to be permanent. You can always update your will and your estate plan. By working with an attorney and being clear about how you want your estate to be distributed, you can protect your loved ones and you can secure your legacy. When I was a banker, I saw some of the effects of a lack of financial education. There were many cases of surviving spouses who suddenly had to make significant financial decisions, but they didn't know how to because they never had to make those decisions before. There were even some people who had never sat down with their spouse or their partner and created a will. That means that a lot of control over what would happen to their estate and even to their loved ones was out of their hands. But the responsibility of estate planning applies to all of us. It's a responsibility that is best to take care of before an unfortunate situation occurs, and you're dealing with a whirlwind of emotions and new and difficult duties. It's also a responsibility that is increasingly applying to women who are statistically more likely to survive their spouse and find themselves in the position to execute the spouse's estate. I say this just to make sure you know the reality of the situation. I've told friends and family members, if you do not have a will, your state government will be the final authority about what happens to your estate and even to family members under the age of 18. Penn State's Office of Gift Planning is making this video available to give all of us some things to consider when planning our estates. My husband and I have our will updated, but we can always learn new things. We hope you find this webinar helpful in preparing or updating your own estate plans. I want to thank you for joining us, and I hope you gain a lot of information from this. So now I'd like to welcome Pat Roenick to share with us some details about our next steps.
Thank you, Lee. We're going to focus on the overall planning tips at first, really looking at some very basic information. So often when I was in private practice and even now at Penn State, people will say, where do I begin? And the best place to begin, and we're going to focus on a number of things, but the first place to begin is with the people planning. You know, you don't do your will for yourself. You do your will for the people who will follow you, your survivors. And this isn't something that your attorney can help you with. You can sit in front of the attorney and they can ask you questions. But as Lee had said, this is something to sit down with your spouse, sit down with people that are important to you and decide who you're going to leave your assets to, what assets you're planning on leaving. Do you even know, have you ever taken an inventory to know what you do have? And how would you share those? When you look at your beneficiaries, people want to treat them fairly. There was always a debate over, is fair equal? Do I treat all of my children? When you go school clothes shopping, does everybody get new shoes or just the one that needs new shoes who outgrew the ones they were wearing on the last day? So as you look at those people, how would you want those assets to go to them? Is there a reason that it wouldn't be a good idea for them to get the funds immediately? Do you provide them outright, or should there be a trust? And if there's a trust, who will administer that trust and make sure things are met? Now, there's a great deal of concern when you're working where your people include minors or those with special needs. And I would encourage you, particularly with special needs, to make sure that you're working with an advisor who can help you with that. So often in private practice, you would find out as you administered someone's estate that mother thought the best thing to do was to make sure that that person who was not going to be in a position to earn things, or you wanted to make sure they had a home, left an asset there and did not take into consideration that that asset might keep them from getting other governmental benefits. But there are specialists who can really help you with that. And I encourage you to consider that. Well, as you look at the people as part of the planning, you also have to look at the roles that these people will play. And this people are not always just individuals. It can also be banks, trust companies, etc. The first role is, who's going to be your executor? Who's best suited to handle that responsibility? This is the person who's going to collect your assets, make sure the bills are paid, and then eventually distribute the assets. They'll be the ones working with the attorney. If you have a number of children, take into consideration how they behave together as growing up. Can they work together as a team? Or if they weren't working as a team, as co-executors, will that create the problem that they don't feel that they've all got a voice in how this is handled? If some in your estate will not receive the funds outright, but rather over time, who will be the trustee? And is that the place where maybe you want to consider a corporate trustee? You know, I can decide as an individual, maybe when my niece or nephew needs a car, and a bank could tell me whether the funds are there to for that car, but it might be a more personal decision as to what kind they need. And a really important decision, what if they haven't chosen where they're going to go to college, where they're going to live, what, are they going to go to college? Those kinds of decisions, the corporate trustee will be able to handle the finances and maybe the investments on that trustee, but maybe it needs a more personal touch. But those decisions are also the rules of the guardian. If you have minor children, who's going to raise those children? And by the way, just because your will appoints a guardian does not mean that the state has to respect that. There can be reasons why the person is not appointed. And there is the guardian of the person and the guardian of the estate. And again, it may not be the same person where someone is the best. You wish they were your mom or your dad. They may not be the best with finances. And it's the kind of place where you may split that responsibility. And also with all of these responsibilities, you want to think about the alternative. You don't know who might predecease you. And that decision may come, deaths or circumstances happen very quickly, so often where it affects more than one family member, where the last thing you're thinking about is changing your own will, and it may affect the course of who serves in any of these roles. Okay, the next thing we wanted to talk about was charitable planning. And this sometimes is a place where it can be helpful in your estate plan is to include charities. And we'll talk later about intestacy, where you haven't taken the time to plan for a will. One thing I will tell you, in over 40 years of practicing law, I have never seen an estate where someone has taken the time to plan their estate where it's distributed the way the intestacy laws would have it. So it's not a good, the intestacy laws are not a good form. And without some planning, charities will not benefit from your estate. So what charities, what's been important to you during lifetime? And when you look at benefiting charities, is this something you might want to do during your lifetime? It's great to have an estate plan, but as you sit down and talk to your advisors about what's going to happen with your assets at death, don't overlook the fact that you've got to take care of your assets during your lifetime. You've got to provide enough for yourself before you think about where you're going to include this, or where you're going to include your beneficiaries. Charities can help there with life income gifts that go beyond the scope of this, but it's an important consideration. Our office is always available to help run illustrations. We have software that's not always available to your advisors. And when you're looking at charities, will you include them as a specific amount or a percentage of your estate, so that you've given to your other beneficiaries everything that you're hoping they would receive, and then have allowed that there's a place for charity with the rest of your estate? You'll also want to consider beneficiary designations. Your advisor needs to know, and you'll want to pull together information, as Judy will talk about more later, about what assets you have. There are things like your life insurance, your retirement assets, annuities that do not pass under your will. So you'll want to make sure, and this is being a good consumer, you'll want to make sure you pull all of that information so that the person planning your will have that, and including reaching out to those places and making sure that you have whatever needs to be included in the beneficiary designation. Okay, tax planning. Tax planning is probably what motivates most people to have a discussion about their estate plans. But interestingly, it doesn't really affect that many people, but it is a great motivator. Whether you have a federal estate tax, and again, this is just the federal estate, you've got to worry about how your state taxes your estate as well. But at a federal level, it's based on the size of the estate. If you're leaving all of your assets to your spouse, there's an unlimited marital deduction. It means there's no federal estate tax. You have an unlimited charitable deduction. Anything you leave to charity is not taxed. And then there's the estate tax exemption. This is how much you can leave to all the other people, those that are taxable events. And it will generate a lot of interest because on December 31st of 2025, we have the sunset of the current law. Now, under current law, you can give away a lot of wealth, almost 13 million to a single individual. You can leave, or as a single individual, I could leave $26 million if my spouse joins me in that. And well, if you're married. And the maximum tax rate on everything over that 26 million is 40%. Now, the sunset on January 1st of 2026, that's going to drop to an individual being able to leave 6.2 million and a married couple 12.4 million. It goes back to the old rates. And the maximum tax rate will increase to 45%. The estate plan is a complete estate plan, really looks at a preparation of documents, coordinating assets, etc., pulling it all together. And this is where your attorney will be most helpful. But you've also got to understand exactly what kind of documents are you prepared to move forward with. For example, a medical power of attorney. This is where you give someone the ability to make decisions about your care. They'll be able to sign for you in a hospital. You also have medical declarations where you say, I don't want life-saving heroic efforts taken on my behalf. And maybe that's not the same person. I mean, I don't know that a medical power of attorney given to a child who's 5 hours away, who may not be right there when decisions have to be made, versus the child that lives with you and making your decisions, or your spouse, that might be the person to hold your medical power, or not to hold your medical power of attorney. You want someone closer who could help in an emergency. But your living will, is that the person who could advocate on your behalf? I mean, when the hospital wants to know, do they have a living will, and they're not in a position to answer, is the person who holds that living will for you going to provide it if they don't agree with your decisions? So think hard about the persons who hold those powers over you or for you. There's also a durable financial power of attorney. You know, there are sometimes things worse than passing away, and that is living with the inability to make financial decisions on your own. You'll want someone you can trust to be able to handle your assets. They are required to do these things for you. And again, on all of these things, think about the naming an alternative, somebody, an alternate who's going to be able to step in if someone can't handle the responsibilities. Of course, there's the will. It can be as complicated or as simple, and that will depend on how you want to benefit and who you want to benefit. But a will can be 50 pages long and cover nothing if you don't own assets in your own name. So you'll want to make sure that the person you're working with, the estate planner, is asking you all the right questions about the assets that you have. Now, some will consider revocable trust or pour over wills. Keep in mind that often there are national seminars, things you can go to, where you are told that it's very important because of probate that you have a trust, that you will, probate takes forever. You need someone who can step in and handle things for you immediately. Well, if you live alone and far from family, having a trust where someone can step in and be your trustee is incredibly important. At your death, if you live in the state of Pennsylvania, the probate process is standing before the Register of Wills. Your executor raises their hand and promises to do all the things necessary to accomplish and stand in your stead. And when they do that, they will be handed what are called short certificates. That certificate lets them conduct business immediately in your name. So you want to understand that wherever you're receiving your information from, and is that there are differences state to state in how things are handled. And you want to make sure they understand the law that will be the law that's important to you. If you move, you'll want to also review your documents with an attorney in your new state. The final paperwork you want to look at, again, are those beneficiary designation forms. You want to make sure they're up to date. COVID was a wonderful time for us to look at those papers. I discovered, though I do this every day, that my 22-year-old had never been included on mine. You get busy. I'm sure her brother and sister would have taken care of them, taken care of her very well. I want to pass this off now to Judy, who will tell us a little bit about where we get started.
Thank you, Pat. Well, a good first step is to first make an inventory of all of your assets and also list the ownership of those assets, how they're titled, whether it's individual or maybe joint owned with a spouse. Our office offers a complimentary estate planning kit that you can download from our website, and you can actually type into it. It's PDF fillable. And it's a great way to organize that information and walks you through the steps of compiling it. It even, Pat talked about taking care of children. A lot of people also want to make plans for pets if they pass away. And just to emphasize again, a good thing to emphasize is to understand that your will is just one piece of your estate plan. A proper plan includes the will, but it also coordinates all of the other assets with beneficiary designations. And as Pat said, it's easy for life to take over and you forget those things. The next step is, once you've compiled that information, is to contact an estate planning attorney. An experienced attorney will be able to help you formulate a sound plan. They'll help you look over your information and finalize your decisions and draft your will and make sure that your beneficiary designation assets are all aligned with your intentions, and make sure that your estate plan has all the applicable documents that Pat mentioned earlier. So people say, well, how do I find an attorney? Well, a lot of attorneys say that they're estate planning attorneys, and so obviously they're a specialist. If you don't know an attorney, you can ask for friends, ask your friends who they might recommend. Someone suggested that maybe the attorney that helped you close on your real estate might know an estate planning attorney. And we're always here, the Office of Gift Planning, to help with referrals in that area as well. And now please welcome guest speaker, attorney Stephanie Sanderson-Brom, partner with Stradley, Ronan, Stevens & Young. Stephanie?
Thank you, Judy. Thank you to the Pennsylvania State University for having me here today as part of this webinar. So I am, as Judy said, a partner in the Trust and Estates Group at my law firm, Stradley Ronan, and I've been with my firm for 20 years. And I specialize, as Judy was talking about earlier, about attorneys that specialize in estate planning. My area of specialty is estate planning and estate administration. And so I'm going to focus, I want to give this umbrella to my conversation that my focus is predominantly in discussing estate planning, Pennsylvania and New Jersey residents. That estate planning is really based in where you are a resident of. So depending on where you live, that's where you should be finding an advisor that specializes in estate planning so that they can advise you of the laws of that state, and also the specifics, different types of ways these documents are handled, because every state does handle them differently. So my take is looking at it from a Pennsylvania and New Jersey perspective. So let me re-emphasize some of the points that have already been made in this webinar, but I think that they're very important, so I don't want them to be overlooked. That your will, your last will and testament is one part of your overall estate plan. It is not your estate plan. That your will is the document that disposes of your assets when you pass away, but it is the predominant document, I should say it that way instead. That there are so many other moving parts to your estate plan when it comes at looking at your assets as a whole, and looking at how, therefore, each asset is handled when you pass away. And some of them are going to be controlled by your will. Some of them will be controlled by a beneficiary designation, as discussed in this webinar. Some of them will be handled by deed, looking at real estate. That doesn't necessarily mean they're handled by your will, especially if you own real estate jointly. So it is important when you're looking at overall your estate plan, looking at your assets in their entirety and trying to understand how they would be controlled when you pass away. And that's really done by opening a discussion with an advisor. And when we talk about the movement of wealth and this time in our country's history of the transfer of wealth, it really is controlling that wealth disposition is looking at talking to your advisor and starting to talk about your overall estate plan and understanding where your assets are. So often I meet with clients who have not done estate planning before, and they don't have an overall picture of where their assets are, what the value of their assets, and what controls them if something happens to them. And so you really want to wrap your arms around that and start getting a general understanding of that to help you and move your estate plan forward. And I also want to give a rule of thumb. I'm going to talk about estate planning that we like to tell clients in my firm. It's about estate planning is not one and done. You don't meet with your advisor and develop one will, and that will is meant to last you for the end of time. A good rule of thumb is about a 3-year rule. Every 3 years, you should be meeting with your advisor taking the dust off your document, looking at it, and then deciding if that document is still in good order. Is it still in good health, if you want to think of it another way? Is it applicable to the laws that are applicable then? And the laws change. So that's why, again, you need to make sure your will is changing and your estate plan is changing with them. Is your will still compliant with the family structure and the relationships you have at this time? Your children get older. The people that you name in your documents may change depending on who your children have relationships with. Again, as we talked about earlier in this webinar, that a will names a guardian to handle the to your minor children if you pass away, or it's the document that's looked at least advise the court who to be the guardian is, and you may want that should always be looked at. And again, the tax law is ever changing, and you want to make sure that your estate plan is compliant with the tax law. So again, you don't want to think of your estate planning as one and done. You want to think about it as ever changing, and that every 3 years, you should be taking a fresh look at it and making sure that whatever you've put in place is still applicable. So now let's look at this slide that we have in front of us of why should you have a will? And again, I think this comes to the point of what does a will do? The will is the document that's disposing of your assets when you pass away. And for you, looking at the point number one, dictating control and distribution of assets, for you to control, you've accumulated this wealth. One way or another, this wealth is attributed to you, and for you to decide how that wealth is going to be used in the future and who's going to handle your affairs. Again, that's a control feature too. Who's going to be the person that should be the executor of your estate? Who should be the guardian? Things of that nature. Those are all named in the will. And so for you to be able to have a say of who that is and not have law control, we'll talk about that in a minute about what law does if you don't have a will, but for you to have a say in that, that's why you need to have a will. We talk about earlier in this webinar about how you're going to benefit who you're going to benefit your assets with. Is it going to be your children equally? Is it going to be in a different type of distribution? Especially mentioned earlier in this webinar is talking about special needs children. And if there is a child with special needs in your life, you're going to make sure you want to talk to an advisor to how to distribute assets to that child under a will properly, so that certain laws are not tripped or changed by the fact that that child now has assets. So it is very important to be able to control your wealth and how your affairs and your assets are going to be handled. You need to have a will. But when you're drafting a will, and you're working and you have a client that's coming to you for an estate planning engagement, you wear two hats as an attorney. You wear the hat of drafting the will in accordance with the client's intentions. And then the other hat you wear is being a tax planner. And in that arena, you're really a death tax planner. And when you look at this point number 2 on the slide of why have a will about minimization of taxes, the way to handle the minimization of death taxes and to understand really how death taxes may affect your assets and therefore what assets would be left over in your estate after tax payment when you pass away, and what's going to be left for your loved ones and for your family. You do that through the estate planning process, and having a will, you can develop it and draft it in a way to best minimize taxes. And that's why, again, that point also goes to why every 3 years you should be talking with your advisor about what's the structure of your will, because the tax law is changing, has changed in the past. And when I talk about tax law, I'm focusing this point on the federal estate tax law. Federal estate tax law is ever changing. It's changed in the past. It's changing again, as mentioned in this webinar, in 2026. And so you want to make sure that you're in the best position through your will structure to handle the minimization of the federal estate tax, and also any state death taxes that apply. Certainly in Pennsylvania, you have an inheritance tax, and in New Jersey, there is an inheritance tax. Not every state has a death tax, but you need to be talking to your advisor about what those taxes are and how best to minimize them. And one of the techniques, this goes to point number 3 about planning your philanthropic legacy. One of the techniques of minimizing death taxes is to decide to transfer your wealth or transfer a part of your assets or a bequest to a charity. And that does minimize taxes. And that is what I've seen in my practice. That is a large catalyst of why folks decide and clients decide to leave charitable bequests and charitable decisions, is to, instead of focusing on payment of taxes, but to change that into charitable giving. Certainly, there's also the thought of creating that legacy for your family, and a type of nonprofit giving that you can create through your will that will last in perpetuity or for a period of time, that will create some type of charitable giving to an institution like Penn State. And you can accomplish that certainly through your will and talking to your advisor. But I do want to tell you that looking just at, I'll mention this now instead of looking at the next slide, through the state laws themselves, if you do not have a will, you're not going to accomplish any philanthropic legacy. And so it is important to remember that if you don't have a will, you will not be able to accomplish those goals, because the law does not include charitable giving as part of where your assets may go if you didn't have a will. So I would definitely make sure that you are talking to your advisor, regarding your charitable plans. When we talk about peace of mind and having a will, my thought is, thinking about when clients are meeting with me and what their concerns are, is taking care of your family. If you're not here, making sure that these things are handled so that your family is in the best position to handle your affairs, they can see what your intentions are. I think it's very stressful for families when someone does not have a will to look at and look at what how state law is going to distribute your assets. But beyond that, then who's to be appointed as executor, or if you don't have a will, it's called an administrator, things of that nature. And so, it is important to be able to express your intentions and to let others know through your will what those intentions are. And so when I look at peace of mind, I really feel like it is that piece of just taking care of your family and knowing you can sleep better at night, knowing that this has been taken care of, and that if God forbid something happened to you, no one has to guess as to what you would have wanted to happen. And that, again, goes also to the last point of making life easier for loved ones when you pass, because it is very stressful for families. And unfortunately, I've seen this play out in my practice when they are trying to guess of what mom or dad wanted to happen or how they would have wanted things to happen, because things haven't been spelled out as precisely as they thought there would have been, or leaving a plan for them as to what's to happen. Even it's just understanding their assets and making sure that the assets, your advisor knows what your assets are. It's very stressful for families to be trying at the moment of death to figure out what assets you have. And often people are left to just using the US mail to do that, which in and of itself is not reliable and very stressful. And so I do feel that last point is taking home that life is easier for your family and your loved ones when you have a will that's taking care of your intentions, and also you've had an advisor that knows where your assets are and what to do with them when you pass away. So I'm going to go to the next slide, which talks about what happens if you do not have a will. Now, I've said this before in my presentation, so I'm going to be repeating a little bit of it, but if you do not have a will, state law, through what's called the intestacy laws, dictate as to who receives your property. So looking again at where you reside, it's going to, the law is going to create as to who is to benefit from them. And looking in Pennsylvania, just taking that as a snapshot, the law would say if you're married, it's going to pass to your spouse. Then it's going to look to certain assets to children. If you don't have spouse and children, it's going to go to your parents and sisters and brothers, things of that, the family tree. Think of a family tree in your mind, and that might not be how you wanted your assets to be handled. Also, state law is going to talk about who can be appointed as the administrator of your estate. And that's a process in and of itself that is a burden on families. To have to go and be appointed administrator is much easier to be appointed as an executor and have a will that you're taking to probate to get the short certificates that were mentioned earlier in the webinar appointed, then to have an administrator appointed. So again, the first step is that you should know state law will govern who gets your property through the intestacy laws. And those the people getting your property, looking at point number 2, may not be, again, who you intend to get your assets. And again, through the developing a will, you can make those decisions as what percentages or what assets go to whom, and how, again, to best handle death taxes on your estate. And without it, you're going to be really left, your family's left to following the rule of the law. And as it says that, the intestacy statutes don't maybe meet your desired distribution. And what I really think of there, again, is potentially your charitable intentions, who you intend to leave money to outside of your family, or to accomplish a legacy for yourself through a trust or other things that you may develop under a will that would never be created under state law. And especially that's important if you have young children, to develop a plan that incorporates some type of trust under will to be the house of assets for your children when you pass away, so that there is someone that is going to handle those assets and make distributions to your children and pay their expenses moving forward, in addition to the guardian and the guardian of the person that was mentioned earlier, and the guardian of the estate / property that was mentioned earlier. So I think these slides really give you an idea, or at least touch the surface of why a will is important, and what happens if you do not have a will. So with that being said, I'm going to turn it back over to Judy.
Thank you, Stephanie. If you have any questions about any of this content, please feel free to reach out to us, the Penn State Office of Gift Planning, either via email or phone. And just a reminder that on our website, you can download a complimentary estate planning kit to help you get started. And we're excited to always discuss those ideas with you. I want to thank the Women's Philanthropic Advisory Board for co-hosting this webinar with us. I want to thank our speakers, and most of all, I want to thank you for joining us today.